The Companies Act 1956. Today, Section 38 of the Companies Act 1956, the effects of alteration in memorandum and the effects of alteration of articles of association. What would be effect on alteration if at all it is done to the memorandum or to the articles of association? So, in section 16 of the Companies Act 1956, provisions of 16 were enabling us to alter the memorandum of the association. And what alterations were we able to do? Provisions of 16 explained us. Similarly, alterations to the articles of association. So we also were able to alter the articles of association. Now, a question may arise: if we alter the memorandum of association, if we alter the articles of association, is there any effect on the subscribers of the memorandum or the members of the company? This is what Section 38 carries the provisions. Let us read it. Section 38 of the Companies Act 1956. Notwithstanding anything in the memorandum or notwithstanding anything in the articles of a company, no matter of the company shall be bound by an alteration made in the memorandum or an alteration made in the articles after the date on which he became a member, if and so far as the alteration requires him to take or subscribe for more shares than the number held by him at the date on which the alteration is made, or in any way increases his liability as at the date to contribute to the share capital of the company or otherwise to pay money to the company. What are we going to understand from these provisions of Section 38? If alteration takes place to the memorandum of association or if alteration takes place to the articles of association, the date on which the alteration takes place, before that date, whatever a member is liable or due to the company, that much only he can be liable. After the alteration to the memorandum or after the alteration to the articles of association, if any member is required to contribute to the share capital of the company or is required to pay any money to the company, he is not liable. This is what we can conclude from Section 38. Let us read it again. Notwithstanding anything in the memorandum or articles of a company shall be bound by an alteration made in the memorandum or articles after the date on which he became a member. That is what, if any alteration takes place, after that alteration, if a member is required to pay more money to the company or if he is required to contribute to the share capital by the alterations to the memorandum or by the alterations to the articles, no member is liable. This is what Section 38 says us. Provided that this section shall not apply So section 38 shall not apply. Wait, let us try to understand. There are two clauses to section 38, provided that this section shall not apply in any case where the members agree in writing either before or after a particular alteration is made to be bound by the alteration. So if at all members of the company agree in writing that they are ready to take into account or they are ready to be bound by the alteration, then section 38 do not apply. It means whatever the alterations take place to the memorandum or whatever alterations take place to the articles of association, if at all members are required to contribute anything to the share capital of the company, they will pay as they have committed in writing. This is what clause A of section 38 comes forward to make us understand. There is another clause called B to section 38. Let us go to clause B of section 38. In any case where the company is a club or the company is any other association and the alteration requires a member to pay recurring or periodical subscriptions or charges at a higher rate, although he doesn't agree in writing to be bound by the alteration. So there are certain clubs, associations or alterations where members may not agree by giving in writing to the alterations. So wherever alterations take place to the memorandum or articles in such companies like club, association, members are required to pay whatever hike takes place, like periodical subscriptions or periodical charges at a higher rate, although they do not agree in writing to be bound by the alteration. Let us read it again. Effect of alteration in memorandum of association and or effect of alteration to the articles. From section 38 we did understand if at all any alteration takes place to the memorandum of association, if at all any alteration takes place to the articles of association, if a member requires an alteration to pay or to contribute to the assets of the company anything or is required to pay anything to the capital of the company, is not bound by the alteration, is not bound by such an alteration to the articles of association or to the alteration to the memorandum of association. But there are some provisos it carries, section 38. So where if a member agrees in writing that he will come forward to consider the alterations and pay the higher side amounts, he may pay. There are certain companies, associations, clubs where members may not agree in writing even though they are expected to pay higher or periodical subscriptions or charges, that is what like pay recurring or periodical subscription or charges at a higher rate, although they do not agree in writing to be bound by the alteration. This is what in simple terminology we can conclude. Let us read it again. Section 38 of the Companies Act 1956. Notwithstanding anything in the memorandum or articles of a company, notwithstanding anything in the memorandum of association or articles of association of a company, no member of the company shall be bound by an alteration made in the memorandum of association, made in the articles of association, after the date on which he became a member, if and so far as the alteration requires him to take or subscribe for more shares than the number held by him at the date on which the alteration is made, or in any way increases his liability as a date to contribute to the share capital or otherwise to pay to the company. So by the alteration to the memorandum of association or alterations by alteration to the articles of association after a certain date or after a date before that he was a member, these alterations may require a member to subscribe for more shares than the number held by him. So he is not expected to honor that alteration. And if at all by that change, by that alteration is expected or his liability is expected to increase, he is not going to be bound by that alteration. Let us go to provisions. In any case where the member agrees in writing, either before or after a particular alteration is made, to be bound by the alteration. So here, in cases where members agree in writing, either before or after a particular alteration is made, they are bound by the alteration. There are certain associations, clubs, companies where though the members do not agree in writing, but they are bound to pay recurring or periodical subscriptions or charges at a higher rate, although they do not agree in writing to be bound by the alteration. From section 38, we were able to understand the effects of alteration to the memorandum of association, the effects of alteration to the articles of association.